Swayam Prabha. Digital India. Educated India.
Students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BSU. Today I am going to present my lecture before you. This is my 32 lectures, and the name of this lecture is Role of UNO in Protection of Human Rights. So I have chosen this topic, Role of UNO in Protection of Human Rights, so that you can get entire information that how far UNO has been effective in protection of human rights. You all might be knowing that UNO came into existence in 1945, and the basic purpose of UNO is to promote and protect human rights. The purpose is specifically mentioned in that charter, that United Nations organization is established to promote and protect human rights, to maintain peace and security. So this is another important objective of United Nations organization. Even when United Nations organization came into existence in 1945 to promote and protect human rights and to maintain peace and security, so it is very obvious that all the member states who have given their consent, who put their signature, they are bound to respect the dignity of human being in their respective countries. So India too has signed that document. So India is also supposed to protect fundamental rights, human rights of its citizens. So our constitution makers, when Indian constitution was adopted in 1949, our constitution makers, they were very much aware about fundamental rights, and those basic rights have been provided in the part 3rd of the Indian constitution, which you all might be knowing. So I would like to highlight certain important provision of UNO, United Nations. The first thing, you all might be aware about UDHR, Universal Declaration of Human Rights 1948. Universal Declaration of 1948, this declaration, you see, Article 1 of that declaration talks about right to equality, and right to equality, Article 1 of UDHR, all the human beings are equal by birth. It is specifically mentioned in Article 1 of UDHR. On the other hand, in order to respect dignity of human being, UDHR also recognizes certain rights, and all human beings have right to live with human dignity. That right to life as a human right is guaranteed, is provided in Article 3 of UDHR. Right to food, without recognizing this right to poor people, we can't imagine their life. So right to food is essential component of that right to life. Right against torture, these are certain rights which are specifically provided in UDHR 1948. I will discuss all these things in detail in coming. Now you can see on your screen, this is Universal Declaration of Human Rights. So the things which are important for your purpose, so I have highlighted only that though this UDHR, Universal Declaration of Human Rights, recognizes certain rights, right to marry, right to property, but right to property or right to marry, this thing is not concerned with this paper, criminal justice system. So Universal Declaration of Human Rights 1948 gives liberty to a human being not to be tortured by authorities, not to be tortured by police. So Article 5 of UDHR says that right against illegal arrest, right against unwanted arrest, right against inhuman treatment. That is the human right of human being. So human beings, all human beings are entitled to be treated humanely. There should be humanitarian approach, and police, they cannot arrest any person without breach of law illegally. So illegal arrest would be violation of human rights provided in Article 5 of UDHR. Unwanted arrest is also violation of human right, because this kind of protection is given under Article 5 of UDHR. Protection against illegal arrest, unwanted arrest provided in Article 5. Right to fair trial, that is also an important right provided in Article 10 of this UDHR. So there are certain basic requirements for fair trial which I will discuss. So right to fair trial, right against illegal arrest, presumption of innocence. You all might be knowing that this is the cardinal principle of criminal jurisprudence, that every person must be presumed innocent unless his guilt is proved before the court of law. So presumption of innocence, that is human right provided in Article 11 of this UDHR. So competent authority has to presume that accused who has been brought before that competent authority, before the court, is innocent unless contrary is proved. So prosecution has to prove that this accused has committed crime, and unless and until prosecution proves this thing, court, competent authorities, they presume accused innocent. And this is this is basic principle of criminal jurisprudence which has got recognition in UDHR under Article 11. Another important, there are certain other rights which you all are supposed to know. For example, right to property, right to nationality, this is also human right, and right to marry. Every human being is free to marry with his or her own choice. So you see, this is a human right. So the point which I want to make it clear, that United Nations organization has made very good effort in the recognition of human rights across the globe, and United Nations organization for the first time tried to bring all the member state countries, democratic countries together to sit and discuss important issues of human beings. And as a result of that, Universal Declaration of Human Rights 1948 was adopted. India is signatory member of that declaration. So India has also paid due respect to all the things stated in UDHR 1948. Now come to another aspect of human right, that is role of Security Council in protection of human rights. You all might be knowing that Security Council is important organ of United Nations organization. So it is the responsibility of Security Council to maintain international peace and security. Security Council was established with a specific purpose to provide peace, to ensure, to protect violation of human rights, and to ensure international peace and security. So in coming years, few years back, you might have seen that how Security Council played important role in maintaining peace in Iraq war, Iraq and Iran war, Iraq and Kuwait war. So 1991 Gulf War, Security Council played important role in maintaining peace between these two countries, Kuwait and Iraq. How? By sending international peace keeping force in Iraq. So international peacekeeping force was deployed in Iraq in order to maintain security and peace in that country. Yugoslavia war is another example where Security Council has played an important role. But few months back, when Russia and Ukraine war took place, and many law-knowing persons started debating this issue that Security Council has failed to establish peace and security in this area in Russia and Ukraine. But we can't say like this. The thing is that when we talk about efficacy of Security Council, we will have to consider all the aspects, all the diplomatic relations, international pressures, international politics. So Security Council cannot decide any issue without affirmative vote of five permanent members. So you all have idea about their Security Council has 5 permanent members, and if one permanent member has given his negative vote, one permanent member is not agreed to any point, then Security Council cannot resolve the disputes. So there has been a long dispute between two countries, USA and USA and Russia. There has been a conflict between these two. So as a result of that, Russia has always opposed matter. So in this context, I would like to say that the emergence of NATO, North Atlantic Treaty Organization, has weakened the efficacy of Supreme Court role of Security Council. So after the emergence of NATO, because you see NATO is led by USA, by America. So many times you might have seen that where Security Council should take action to establish international peace and security, but it is the NATO which comes forward and take action in that. So you see the intervention of NATO in Afghanistan and Taliban crisis and other countries, so definitely has weakened the role of Security Council, because Security Council is one important organ of United Nations organization. So the primary duty, the primary responsibility lies in Security Council to maintain international peace and security. So how NATO will start, how NATO will come forward to maintain peace and security? So many countries, democratic countries, have raised objection that NATO should not intervene in this kind of conflict. So now with the help of these examples, you can understand the role of Security Council in establishing international peace and security. Now let us understand the role of ICJ, how International Court of Justice has been effective in protection of human rights. So I have chosen this, you can see on your screen. With the help of this slide, ICJ and human rights. So international ICJ, that is International Court of Justice. So we will try to understand that how International Court of Justice has played significant role in protection of human rights. Since the topic is role of UNO, role of United Nations Organization in protection of human rights. So I have covered each and every organ which has played, whether they have played important, significant role in protection of human rights or not. So that is why I highlighted the role of Security Council in protection of human rights, and second important organ which is ICJ, International Court of Justice. So we will see that how International Court of Justice has been effective in protection of human rights across the globe. As you might be aware about International Court of Justice, ICJ has 15 members, and ICJ has to decide disputes when state party brings any matter before ICJ. So it is specifically mentioned that any aggrieved state can file a case in ICJ, and ICJ will decide that case. So International Court of Justice can decide any dispute pertaining to violation of human rights, and any member state can file a case in International Court of Justice where human rights are violated by another country, either by way of war or by way of aggression, external aggression. So you might have seen that in external aggression or during war period, during war conflict between two countries or more than two countries, human rights are violated, refugee problems, and big countries or powerful countries, they try to impose their wishes over poor countries, very small countries. So, and poor people, citizen of that country, they have to suffer, they lost their family members. So in such a situation, member state can file a case before the ICJ, and International Court of Justice can take. So you see how I have chosen this three important aspect. In case of war prisoners, ICJ can play important role. Refugee problem is a big problem. So refugee, where human rights of refugees is violated, then this matter can also be brought into the notice of ICJ. Extradition, this case can also be covered by ICJ. So though I am not talking about efficacy of International Court of Justice, whether International Court of Justice is effective or not, it's not matter of efficacy of a court. It's a matter of how International Court of Justice has been effective in protection of human rights. Whether it is effective or not, it may be a matter of debate. But this ICJ can decide this kind of dispute. But you can imagine that why strong countries, powerful countries will take that issue, will bring that issue before this ICJ. For example, if United States of America has any problem, so can you imagine that country will go to the ICJ, that country will knock the door of ICJ. If India has some problem, then can you imagine that India will go to ICJ and knock the door of ICJ? Because it is a matter of sovereignty. So due to that concept, every democratic country is sovereign in its internal as well as external affairs. So sovereign country can decide its all disputes independently and by its own measures provided in domestic law. That is why, because of this concept, sovereignty concept, no country will think to go to knock the door of International Court of Justice. So many times it has been seen that big countries, powerful countries here means democratic countries which have power, which are developed country or developing country, they will not try to knock the door of ICJ, International Court of Justice. But even though if matter is brought into the notice of International Court of Justice, ICJ can play important role as per statute, as per the provision of the ICJ. It can take cognizance of the matter which is brought into its notice. Now come to International Covenants on Human Rights. So you can see on your screen that there are three important conventions. First is ICC, this UDHR 1948, and which I have discussed, Universal Declaration of Human Rights 1948, ICCPR, International Covenant on Civil and Political Rights 1966, International Covenant on Education and Social Cultural Rights 1966. So ICCPR 1966 talks about certain rights, for example, right to vote. Right to vote, according to this ICCPR, is a human right. Every human being, after attaining the age of majority, is allowed to participate in political process. India too has recognized this right to vote, but there is slight difference with regard to this right to vote. In our legal system, right to vote is a constitutional right. Right to vote is not a fundamental right. Why? Because our right to vote is not recognized in the Part 3 of the Indian Constitution. Right to vote is recognized as a constitutional right under Article 326 of the Indian Constitution. So according to Article 326 of the Indian Constitution, every person who has attained the age of majority, he or she is above 18 years, can cast his or her vote, can participate in electoral process. So Article 326 of the Indian Constitution recognizes right to vote as a constitutional right, not as a fundamental right. So this thing you need to remember, and this right to vote is recognized as a human right in ICCPR 1966. Deliberately our constitution makers put this right under Article 326, Part 3rd rather than Part 3rd of the Indian Constitution, because once right to vote, if right to vote would have been recognized as a fundamental right, then every prisoner, accused, offender who can claim that this is the fundamental right and provided in the Part 3rd of the Indian Constitution, so they are entitled to cast their vote. So even Supreme Court in Ankur Chand Pradhan versus Union of India, Supreme Court held that right to vote is a constitutional mandate. It is a constitutional right, a statutory right, because it is provided in the People Representation Act 1950-51. There are two statutes, you all might be aware, the People Representation Act 1950 and 1951. So right to vote is a statutory right as well as a constitutional right, but not a fundamental right. You all need to remember this thing. Right to freedom of speech. So how United Nations General Assembly has been effective in recognizing all these rights as a human rights. So you may be aware that right to freedom of speech and expression is a human right provided in this international covenant. This freedom of speech and expression has got due recognition in the Part 3rd of the Indian Constitution. Part 3rd of the Indian Constitution recognizes right to freedom of speech and expression as a fundamental right. Every citizen of this country has liberty to speak whatever he or she wants. He can express his view or she can express her view or whatever he or she thinks, but subject to the restrictions mentioned under Article 19, Clause 2 of the Indian Constitution. So you all must be aware about that these human rights which we can see in UDHR, ICCPR, ICESCR, these human rights have got recognition in our constitutional scheme, have got recognition in the Part 3rd of the Indian Constitution. So we are fortunate enough to have all these human rights in the Part 3rd of the Indian Constitution. Now come to right to education, right to work, right to freedom of religion. These rights are considered as important human rights. All the human beings are entitled to get these human rights only because of they are human being. Right to education as a human right, it is provided in International Covenant on Educational, Social and Cultural Right that all human beings shall have right to education. And because this is International Covenant on Education, Social and Cultural Right, so all the member states who are party to this international covenant are bound to have these human rights, these provisions in their respective states. If India is party to this international covenant, so India too will have to recognize these rights in this country, and you will be happy to know that right to education has become part of Part 3rd of the Indian Constitution. Right to education is a fundamental right. Earlier it was not. Right to education was not expressly accepted as an essential component of right to life or personal liberty, Article 21. Earlier it was not considered as fundamental right, but in 1992 Supreme Court for the first time held that right to primary education should be considered as fundamental right, and state should provide education free of cost to poor children up to the age of 14 years. As a result of that, Indian Parliament has enacted special legislation for what? To provide education free of cost to poor children. That is known as RTE, Right to Education Act 2009. So Right to Education 2009, that statute, that special legislation has been enacted by Parliament in order to provide education free of cost to poor people. In that statute, the one thing is very important which you need to remember, that it is specifically mentioned in that statute that every state shall ensure, every state shall make an effort to provide education free of cost up to the age of 14 years. You might be knowing that Article 21A, which talks about right to education, right to primary education, was inserted by the Parliament through Constitution Amendment Act and Article 21A must be read in the light of Right to Education Act 2009. So the point which I wanted to justify, that right to education was accepted as a human right in 1966 by that international covenant, and Indian Parliament has enacted special legislation in order to give education free of cost to poor children in 2009, Right to Education Act 2009. Right to work is also a human right, though this right to work is recognized in Part 4th of the Indian Constitution. You might have read in Part 4 of the Indian Constitution, which talks about directive principle of state policy, right to work. This right has not been expressly accepted as a fundamental right in the Part 3rd of the Indian Constitution. So our constitution makers, when they were drafting our constitution, they had idea about this right, and deliberately they put this right to work, in the Part 4th of the Indian Constitution, because in 1949 the economic condition of this country was not so good. So it was thought by our constitution makers that this right should be put in Part 4 of the Indian Constitution, and when this country would become independent, would become economically, financially sound, then India would be at liberty to recognize this right as a fundamental right in the Part 3rd of the Indian Constitution. So right to work, it is specifically mentioned in Part 4th of the Indian Constitution that a state shall endeavor to provide employment to its citizen. But thanks to the government, that government has adopted a scheme that you all might be knowing, that the name of that scheme is Mahatma Gandhi National Rural Employment Guarantee Act 2006, in brief that is known as Manrega. So by that statute, Parliament has made an effort, good effort, to provide employment to the people of rural areas, and it is the guarantee. You see, that act gives guarantee of 100 days employment to each and every household, to each and every poor family. So we can say that India is in that direction where right to work has been recognized as a statutory right by that statute, and in coming years we do believe that this right to work would be a fundamental right, and this country would be in position to provide employment guarantee to our citizens. Right to work. Now come to right to freedom of religion. This is also a human right in that covenant. So right to freedom of religion is a fundamental right in the Part 3rd of the Indian Constitution. Every citizen of this country is free to profess his or her religion according to his or her own wishes. So you see, these are three important international covenants on human rights, and all these three important international covenants are considered as International Bill of Human Rights. So International Bill of Human Rights talks about human rights of the human beings, and this International Bill of Human Rights has covered each and every aspect of human right. For example, right to life, right to equality, right to education, right to work, right to vote, right to freedom of speech and expression, right to freedom of religion. So nothing has been left so far as human rights are concerned. So each and every human right has been recognized under these three important covenants. Though UDHR is not covenant, but that is a declaration only. Many times it is argued that declarations and covenants are slightly different. There is slight difference between these two: UDHR, Declaration of Human Rights, and Covenant on Civil and Political Rights. Since covenant is a bilateral or multilateral agreement among the member states, so member states are bound to respect the provisions provided in that multilateral agreement, that is covenant. So it is said that international covenants are more important than declaration, because UDHR is merely a declaration of human rights. On the other hand, international covenants or multilateral agreement, and agreement, you all might be knowing that if agreement is breached by any member, by any individual, so that member can be held liable for the breach of contract, breach of agreement. Likewise, international covenants plays important role in putting pressure upon member states to follow the contents provided in that international covenants. So any member state which has put its signature on that agreement is supposed to follow that agreement. So this is another aspect of covenant and declaration which I have just highlighted, so that you can get entire information about covenant and declaration, what is the difference between covenant and declaration. Do hope that you all have understood the things which I have discussed. Now come to another aspect of multilateral agreement. You can see on your screen that I have chosen this component, Convention on Rights of Child 1989. So this is another important aspect of United Nations organization, where United Nations General Assembly has played significant role in recognizing the rights of child globally. So how United Nations General Assembly has played important role, I would like to highlight certain important features so that you can understand. In 1989, United Nations General Assembly for the first time made a good effort to evolve certain basic principles for the betterment of children across the globe. As a result of that, Convention on Rights of Child 1989 was adopted. This briefly it is referred as CRC 1989, Convention on Rights of Child. This Convention on Rights of Child is an important international instrument through which children are provided justice. Children have been taken care of by the member states. All the member states which are the party to this international convention, they are bound to implement the guidelines provided in this CRC 1989. The irony of law is that, which I will try to explain you. You see, CRC 1989 talks about, gives precise definition of child. Who is child according to this CRC? According to CRC 1989, a child is a person who is below 18 years. But in our constitutional scheme, if you have any idea about Article 24 of the Indian Constitution, Article 24 of the Indian Constitution says that no child below age of 14 years shall be deployed in any industry, factory or hazardous establishment. Let me repeat it. Article 24 says that no child below the age of 14 years shall be employed in any industry, factory or hazardous establishment. Meaning thereby, a person who is above 14 years, say 15 years, 16 years, 17 years, can be appointed in any industry or factory or in any hazardous establishment, because Article 24 of the Indian Constitution only prohibits the state or individual not to employ any child who is below 14 years in any industry or factory who is below 14 years. Meaning thereby, according to Article 24 of the Indian Constitution, the age of child is fixed as 14 years. On the other hand, this Convention on Rights of Child 1989 has fixed the age of child as 18 years. So there is difference between with regard to age of child, which I wanted to make it clear. So can you imagine that a person who is above 15 years or 16 years has got sufficient maturity to understand the nature and consequences of his act, what he is doing or she is doing, and he or she can be appointed in any industry or factory or in any hazardous industry, because Article 24 only prohibits that child who is below 14 years cannot be employed. Above 14 can be. On the other hand, CRC has fixed that is 18 years. So my humble suggestion is that this Article 24 of the Indian Constitution should be in conformity with that international instrument, so that we can protect the childhood from exploitation. So now come to another aspect of CRC 1989. This is one anomaly which I have understood with regard to the age of child, Article 24 and CRC 1989. Right to equality, CRC talks about right to equality. Every child is equal in eye of law, irrespective of caste, creed and religion. All the children are equal by birth. So, and that equality clause is also embodied in the Part 3rd of the Indian Constitution, in which you all might be knowing that Article 14 specifically says that state shall not deny to any person equality before law or equal protection of law within territory of India. State shall not deny to any person. So any person here means child, adult, old. So there is no specific age. Any person here means even a child. So this CRC was adopted in 1989, and we people have already recognized this right to equality as a fundamental right under Article 14 of the Indian Constitution to to all the persons irrespective of caste, creed and religion. Now come to another important right which a child can avail, that every child has right to live with human dignity. Every child has right to live with human dignity, which I have mentioned on this, you just can see on your screen. This precious right is also recognized in Part 3 of the Indian Constitution. Every child has right to live with dignity. Article 21 of the Indian Constitution specifically says that every person, so person word has been used in Article 21 of the Indian Constitution, which means child is also included under Article 21. CRC 1989 says that all children have right to live with human dignity. Likewise, Article 21 of the Indian Constitution says that all persons have right to live with human dignity. So child has already been included in Article 21 of the Indian Constitution. So there is no doubt at all that we people are more cautious about rights of child. So deliberately we have used person, not citizen, not particular age in Article 21 of the Indian Constitution. So by Article 14 and 21, you can understand that this equality or right to live with dignity, these rights have already been recognized under Article 14 and 21 of the Indian Constitution, which CRC's Convention on Rights of Child gives more emphasis. Right to food, that is also important right provided to a child in this CRC. And right to food was provided in the Part 4th of the Indian Constitution, that states shall endeavor to provide nutritious food to the children of this country. So nutritious level, and it is state liability, obligation of state to provide food to poor children. But our Supreme Court has recognized that right to food is essential component of right to life. It should be included, it should be treated as fundamental right under Article 21 of the Indian Constitution, so that we can establish hunger-free society in this country. Right to education, these are certain important rights which have been provided to the children by this CRC 1989. Right to birth, right to nationality, these rights are specifically provided in CRC 1989. So I do believe that you all have understood this Convention on Rights of Child 1989, how United Nations organization has played a significant role in protection of human rights, in recognition of human rights. Firstly, United Nations General Assembly has recognized those rights, and important agencies of United Nations organization have played important role in protection of human rights. Firstly, you all are supposed to understand that how far UNO has been effective in recognition of human rights. So recognizing rights as a human rights is different thing, and protecting those rights protecting those human rights with the help of United Nations agencies is different thing. So you all need to make difference between these two. You all need to understand the difference between these two. I have highlighted role of Security Council. I have highlighted role of International Court of Justice. I have highlighted the role of United Nations General Assembly in the recognition of human rights and in protection of human rights. Firstly, human rights have been recognized by UNO, particularly General Assembly, and then after you will have to see that how human rights have been protected by several agencies designated for protection of human rights. Now come to another important agency, that is known as ILO. You can see on your screen that International Labour Organization and Human Rights. I have chosen this slide, and nomenclature used on this screen, ILO and human rights. So you all might be knowing that International Labour Organization is a subsidiary organ of UNO, which has to ensure the rights of laborers across the globe. So ILO, this International Labour Organization, was established with a specific objective to ensure the human rights of the laborer across the globe. So what should be the working hours of workers? What should be the hygiene condition of any establishment or industry, factory where workers are working? Time hours, hygiene and sanitation related problems should be taken care of, and education of their children, education of children of workers working in factory industry. So all these things must be taken care of by state. So state which have put their signature to that to that convention. India is also party of that. India is also a member of this ILO, and ILO has prescribed certain guidelines for the workers working in working industry. So you see how ILO has been effective in recognition of certain rights of workers, laborers, right to work, right to equal pay for equal work. So states shall not make any discrimination on the ground of race, caste, sex. Female workers are entitled to get equal pay for equal work. Female women are entitled to get equal pay for equal work, which men are getting. So on the basis of sex, state will not make any kind of discrimination. Right to equal pay for equal work is a fundamental right. Right to health. So it is the duty of state to ensure good health of workers working in an industry or factory. Right to food, right to clean environment. These are certain rights provided by ILO, and ILO will have to issue guidelines from time to time so that the financial condition, social condition and economic condition can be rectified, can be ameliorated. So in order to improve financial and socio-economic condition of workers, this ILO has played significant role. Now come to this another aspect of human rights. I have chosen this, the United Nations and Human Rights Council. You all might be knowing that United Nations General Assembly established Human Rights Council for the protection of human rights across the globe, and India too is member of this Human Rights Council. Human Rights Council was established to protect human rights of the human beings across the globe. So United Nations General Assembly for the first time tried to bring all the member states on one platform so that they can give their consent to protect human rights in their respective countries. So I think I have covered each and every aspect of human rights, and I have also covered the role played by United Nations organization in protection of human rights. You all remember that how United Nations organization has been effective in protection of human rights and in recognition. So firstly, human rights are recognized, and then after human rights are protected by these subsidiary agencies and important agencies of United Nations organization. So I have covered Security Council, International Court of Justice, ILO, International Convention on Rights of Child, so that you can get entire information pertaining to human rights of children, human rights of elderly people, human rights of women and men. So and one important thing which I have also covered, that is international in Covenant on Civil and Political Right, UDHR 1948. So I think that if you all have understood all these things, you all be to clear any examination related to human rights. And if you remember all these things, definitely you can substantiate your argument with the help of these conventions, with the help of this ILO, with the help of this discussion. And I do believe that you all must have understood the things which I have discussed, which I have highlighted in this lecture. So with this, I would like to conclude my lecture, assuming that you all have understood the things which I have just discussed just now. Thank you all.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.